My lords, I wish to begin by saying that in constitutional arguments, there can be multiple approaches.
From London, my lords. London is behind all these problems.
May I only correct my friend, my lord, I don't live in London. I'm only in the suburbs. My lord, having said that, there are, my lord, multiple approaches. One, my lord, is what we call traditionally the historical argument. The second, my lord, would be a textual argument. The third is a doctrinal argument. The fourth is prudential, and the last is structural argument. Well, these are all well-known methods of interpreting a constitution. These are broadly, my lord, the topology of constitutional arguments. In this case, whatever approach, my lord, we may adopt, the end result will be the same. Whichever way we proceed to look at this matter, there will be...
Who are you appearing for in this batch of cases?
I'm appearing, my lord, so if I may just point out to it, I'm appearing in writ petition civil 1104 of 2019.
And petitioner there?
Yes, my lord, there is a petitioner,
Muzaffar
Muzaffar
Iqbal
Khan. Yes. My lord, my written submissions are also on your lordship's record.
Yes, Mr. Bhatt.
So, my lords, I'm going to urge for your lordship's consideration 4 important propositions. The first is the Constitution of India and the Constitution of Jammu and Kashmir speak to each other. They exist together. And their complementary existence is the quintessence of the relationship between India and Jammu and Kashmir. The second.
So they speak to each other and
Yes.
complementary
And
existence.
they're complementary constitutions. With respect to Justice Nariman in one of the judgments, he called it subordinate. I think the word is slightly inapposite. I would say complementary.
Yes.
The second, my lord, is that Constituent Assembly by its very definition is a primary assembly which is vested with this extraordinary task of framing a constitution. That is why, my lord, the amending power is always called a derived power. An amending power, a power to amend a constitution, is always called a derived power. And here, my lord, we have 2 constituent assemblies. The Constituent Assembly of India, and we also have, under the Constitution, recognized by the Constitution, a Constituent Assembly of Jammu and Kashmir. This is the second. But what is its implication? I'll deal with it. Then the third. the impugned orders, that is CO272 and CO273, in sum and substance, do away with the Constitution of Jammu and Kashmir. That, my lord, is impermissible. It is not authorized. The last is about this expression people. Here, my lord, people have both the sense of being persons, but in the constitutional context, they have a legal and juridical existence.
Yes.
If Honorable the Chief Justice yesterday and it is perhaps a critical observation that in any representative democracy, we must look for expression through the institutions under the Constitution. And, my lord, I'm going to urge your lordships to consider that the expression Constituent Assembly and legislature of a state are both institutions recognized under our Constitution. I will submit, my lord, that the basic structure which your lordships have to discern in this case to determine whether there could be any abrogation of it will be deduced both from the Indian Constitution and the Jammu and Kashmir Constitution. I will also urge your lordships to employ.
Just one second. Yes, Mr. Bowman.
I will urge your lordships to apply what is called the degree test or the effect test applied by Chief Justice Kapadia in a case called Glendalough And it is by applying that test we assess the extent of abrogation. Most importantly, my lord, our Constitution recognizes a symmetric federalism. And the purpose of asymmetry is to take note of special conditions and special needs of people. Now, my lord, the great colossus, Dr. Ambedkar, introduced the Constitution, and his introductory speech had two themes. That speech, my lord, is available for your lordships in document volume 8. And in that opening speech, Dr. Ambedkar speaks about the Indian Constitution being federal. And he also says that people who live in a state can be given special rights, special privileges. There was another question which I think I heard my Lord Justice Gavai mention, which was there were also princes who merged their states at the time of the Constitution. There were agreements. What was the status of those agreements? Could they not be abrogated? And my Lord, there is some answer which needs to be offered to that question. It's a very important question. Jammu and Kashmir was not like any other state at the time of accession. It was not like any other state. And I'll give your lordships 3 reasons. The first, Jammu and Kashmir was a state which had its own constitution prior to the Act of Accession. They had a constitution of 1939. Two, the accession by the Maharaja was qualified because people were still in the process of making up their mind. What, my lord, the Indian Constituent Assembly did is that just as they felt a decision can only be taken by the people of a country, they thought it's appropriate and necessary that the will of the people is ascertained. My lord, that is the first hallmark of this case. What did the Constituent Assembly and later in our constitutional text proffer to do? They maintain the highest sense of democracy and respect, just as we are enacting and giving unto ourselves a constitution. We must give that Constituent Assembly to determine their future. And that, my lord, is the reason why in draft Article 306A, which was introduced by Mr. Gopalaswamy Iyengar, spoke about the Constituent Assembly of Jammu and Kashmir taking a decision. Now, my lords, the entire controversy or dispute has been presaged, if I may say so, on one misunderstanding. Namely, there is a unilateral exercise of power possible by the president under Article 370. This is how, my lord, we've looked at the provision. Now I'm going to show to your lordships, it is exactly the converse. What is the converse? I'll now take you, my lords, to some portions of the debates of the Constituent Assembly of Jammu and Kashmir, and then your lordships would notice what was their final resolution. My lords, they passed a resolution, and the text of that resolution is the answer to the case. It is an answer to many questions. We have been very uncertain that did the Constituent Assembly take a decision under Sub-Article 3? What was their position on Article 371? Your lordships will find answers. But I'm summing up first, my lord, so that your lordship knows what is that answer going to be. My lords, just as the Constituent Assembly debates of India are inspiring, the Constituent Assembly debates of Jammu and Kashmir are also inspiring. Your lordships will notice that it was really on the basis of Rousseau's model of representative democracy that the Constituent Assembly itself was formed. But more importantly, they took their decisions in 3 steps, my lord. 3 steps. The first is they left India in no manner of doubt that they have faith and respect for the people of India and are acceding to India. The second is, my lords, they were looking at all constitutions of the world, just like Sir B.N. Rao did, just like Dr. Ambedkar did. In fact, my lord, one of the greatest gifts of government publications are the complete collected works of Dr. Ambedkar, published by the Maharashtra government. And my lord, the editorial chairman is one Mr. R.M. Gavai. And that painstaking effort of putting all his letters together, and all his letters, my lord, are quite remarkable. Having said that, my lord, they had many constitutions to look at. They also looked at the Indian Constitution. And they said, we will need some special provisions for us. We will need some exceptions for us. one of the first states in India, my lord, which looked at land reform was Kashmir. It was actually their throbbing concern at that time that we must give rights over the land to people, and there must be permanent residence, and people must have rights. So, my lord, they wanted some exceptions. So the first time, my lord, decision to accede. Second, they said, we will frame our constitution, but we will request the government of India that its constitution with the exceptions be brought into it 70. That is why, my lord, we have 3 constitutional orders, which I'll show you shortly, one of 50, 52, but most importantly, 54. My lord, it was the Constituent Assembly of Jammu and Kashmir which invited, under Article 371D, for the application of the provisions of the Constitution with exceptions which were required in Jammu and Kashmir. I'll show you, my lord, that you will see it very shortly. And, my lord, the government of India accepted that request and issued the 1954 order. And then they said, if we have already got an order subject to exceptions and modifications, and in that, my lord, they omitted many parts of our constitution because they wanted it to come in their own constitution, like legislature. So the legislature, my lord, is actually established under the J&K Constitution. The High Court of Jammu and Kashmir is established under the J&K Constitution. So they said, we will take the 54 order as Indian Constitution as applied to Jammu and Kashmir. And that is how, my lord, the Jammu and Kashmir Constitution was born in 1957. The Jammu and Kashmir Constitution on 26/1/1957 recognized the application of the provisions of the Indian Constitution under the 54 order, and also had separate provisions, including, my lord, the autonomy in respect of framing of laws. And this is quite important, my lord, because this is the way 2 constituent assemblies, as a product of their fruitful energies, through now the Constitution, speak to each other. So, my lords, even though the word temporary occurred in the marginal note, the resolution of the Constituent Assembly of Jammu and Kashmir, my lord, which I'm speaking and I'm putting it within quotes, was that the Constitution of India must apply with these modifications. But more importantly, they said, Article 1 and Article 370 must continue. I'm talking of an affirmative resolution, my lord, of a Constituent Assembly. It is not a matter of any non-formalistic expression. And it is that formal resolution read with the J&K Constitution, which finally, my lord, fall up for your interpretation. My lord, what is significant is the two constitutions, I said, speak to each other. Which is that provision through which they speak to each other? It is Article 370. So, my lord, Article 370 was not a repository of untrammeled power of application of constitutional provisions. No. Article 370 was the medium by which the Indian Constitution could be applied, and they could also act in terms of their constitution. And, my lord, here lies what I call as a dual obligation. The dual obligation, my lord, is to be discovered, one, in the words of section 147 of the Jammu and Kashmir Constitution. And the second are the words in Article 370 itself. In section 147, my lord, one of the laws which could never be touched by the Legislative Assembly ever in the exercise of its amending power was the provisions of the Constitution of India as applied to Jammu and Kashmir. This is, my lord, in some contrast. And again, I'm deeply grateful to my lord, the Chief Justice, who, again, in a thought-provoking observation, referred to Article 372, the power of adaptations. And in that, your lordships will notice the president can bring it in accord with the Constitution, but the legislature of the state, which is competent, can always pass a law repealing, modifying, varying it. Your lordships recollect that provision in the Constitution. This is not there in 148 at all. So 148 treated the provisions of the Indian Constitution as sacrosanct. And, my lord, what did we under 370 offer? Under 370, we offered the ability to frame a constitution and the ability to offer our constitution subject to special exceptions. Your lordships have not seen those exceptions. When your lordship sees those exceptions, your lordships will appreciate that this is not a simple constitutional order. This is an order which is a product of bilateralism. And, my lords, our constitution, by its very nature, has so many checks and balances that bilateralism can be seen as at the imprimatur of our constitution. So, my lord, the only exceptional provisions where you can have unitary action are few, far limited, and conditioned, my lord, by a temporary purpose. Having said that, my lord, may I just take you to a few documents so that I quickly make the point?
Yes.
I also want to say one thing, my lord. I had Mr. Sybil cite the decisions on Article 370 yesterday. There was one more, Justice Nariman's decision, which needs to be cited. But, my lord, I want to just sum up and tell you what are these decisions quintessentially saying. Justice Bhargava in Sampat Prakash notes that the Constituent Assembly did not want to abrogate Article 370 and instead permitted its continuance. When your lordship see that sentence with the resolution of the Constituent Assembly of Jammu and Kashmir, your lordships will be left with no manner of doubt that that is the correct legal position. The judgment in Damu, which was cited by Mr. Sybil, is a case, my lord, where there was an amendment to the Jammu and Kashmir Constitution by the Assembly, which was called the Sixth Amendment. In Jammu and Kashmir first. And Jammu and Kashmir said, Sadr-e-Riyasat will now mean governor. And therefore, my lord, Article 367 was amended to bring it in accord with Jammu and Kashmir Constitution. That is the judgment of Justice Sikri. But more importantly, my lord, Justice Sikri refers to this very judgment in Keshavananda Bharati and said that amendment did not alter the fundamentals or the basic structure of the Jammu and Kashmir Constitution. Now, my lords, just a quick recount of dates, and I go straight to what needs to be seen. Your lordships have been told that there was a 1939 constitution. And that, my lord, is Documents Volume 6, page 199. I'm not going to read it, but one of the features of that constitution, my lord, as Justice Gajendra Gadkar noted, is that the Maharaja had all legislative, judicial, all powers vested in the Maharaja under the 39 Constitution. On 26/10/47 is where, my lord, Hari Singh signs the instrument of accession. Your lordships have seen it. It is Document Volume 1, page 9. But it was not, my lord, the kind of accession which many other Maharajas did, for the reason the other Maharajas signed supplementary instruments of accession and merger agreements. Now, between the time he signed the agreement and the drafting of our constitution, our Constituent Assembly, my lord, did not ask the Maharaja to discover the will of people. They acknowledged that there should be a Constituent Assembly by which the will of the people of Jammu and Kashmir is ascertained. So, my lords, even though he was the titular head, in some sense, the people of Jammu and Kashmir were acting now in a sovereign capacity to determine in a Constituent Assembly what should be their decision. This is the difference, my lord, between the cases where agreements have been superseded or privileges have been superseded and this case. Why? Because when the accession happened completely, my lord, it was between the people of Jammu and Kashmir and India. Of course, my lord, your lordships have been told that on 27th October 1947, Lord Mountbatten, the Governor-General, accepted the instrument of accession, that is document volume 1, page 1112. And 5th of March 48, my lord, there was an interim government appointed by the Maharaja for administration. And 17th of October 1949 is the date when page 1173, when N. Gopalaswamy Iyengar introduced Article 306A. One day before, my lord, our constitution was going to be adopted. One day. On the 25th of November 49.
sorry.
Maharaja.
Can you give us the date
25th,
again?
my lord, 25th.
25th November?
November 49.
Yes.
The Maharaja of Jammu and Kashmir said, India is about to frame a new constitution. And for the sake of continuity, the provisions of that constitution must govern us till such time as is necessary. That is at, my lord, Documents Volume 4, page 379. My lords, on 26 January 1950, of course, our constitution came into force. But now I would like your lordships to go past this date and please see first the proclamation convening the J&K Constituent Assembly that is dated 1/5/51. And would your lordships kindly turn to Documents Volume 6, page 276. If your lordship sees this document, 276.
276.
This is the proclamation dated 1st of May 51, convening Jammu and Kashmir's Constituent Assembly. Whereas it is the general desire of the people of the state of Jammu and Kashmir that a Constituent Assembly should be brought into being for the purpose of framing a constitution for the state. Whereas it is commonly felt that the convening of the Assembly can no longer be delayed without detriment to the future well-being of the state, and whereas terms of the proclamation of the Maharaja dated 5th of March 1948 in regard to the convening of a National Assembly as contained in clauses 4 to 6 of the operative part, therefore do not meet the requirements of the present situation, which is why, my lord, the change of language. And please see, I, Yuvraj Karan Singh, do hereby direct a Constituent Assembly consisting of representatives of the people elected on the basis of an franchise shall be constituted forthwith for the purpose of framing a constitution for the state of Jammu and Kashmir. Then, of course, my lord, there was the other logistics were set out in the rest of the proclamation. Now, my lord, after this, the Constituent Assembly of Jammu and Kashmir meets. And by this time, because of the instrument of accession that certain entries in the union list on the three subjects, my lord, can be made applicable, the first constitutional order of 1950 was passed. And that, your lordships will find, is in document volume 3, and please see page 4 of that document volume.
Document volume 3, page 4.
And this is one of the 1950 order. And your lordships will notice that this 1950 order takes place in consultation with the government of Jammu and Kashmir, because these are all in respect of matters connected with accession. Now, my lords, the second schedule also applied some provisions of the Constitution, because there must be a parliament, there has to be an acknowledgement to parliament, and your lordships will find there are 3 columns, my lord, in the schedule 2. One is provisions of the Constitution applicable, the second is exceptions, and the third is modifications. And your lordships will notice at page 7, in part 11, on the extreme right, clause 1 of article 246 shall apply, subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply in relation to the state. This order, my lord, as your lordships have seen, is the first order. Now, my lords, alongside, let me take you to the assembly. This is the beginning. And now let us see the Jammu and Kashmir Legislative Assembly itself. Your lordships will find this in documents volume 7.
What page of document 7?
Yes. Now, would your lordships kindly look at page 32? I'm, my lord, trying to set out the extraordinary goodwill between India and the state framing a constitution and how it was expressed. Please see page 32. It's Appendix A.
Where is this?
Page 32. PDF page 32, my lords. Message of goodwill.
Running page 1391.
Yes, that is the print page. And this, my lord, is the message from the President of the Indian Union. On this historic occasion of the inaugural meeting of their Constituent Assembly, I send my sincerest greetings to the people of Kashmir and their beloved leader, Sheikh Abdullah, and hope that the Assembly will be guided in its deliberations by the single aim of shaping the life of the people of Kashmir as to make them happy and prosperous. And then, my lord, your lordships may kindly come to page 250, PDF.
It's the same volume.
Of the same volume. Your Lordship sees after, in quotation marks, Sheikh Muhammad Abdullah reads, and he says, and that, my lord, is only to indicate how they set about their debates. This assembly, which is the center of our hopes and aspirations, held its first meeting in the first week of November 1951. It is now meeting again after an interval of nearly 4 months. In the last session, I had drawn your attention to the fact that though this assembly possesses the unquestioned right to decide the future of the country, and that this House is going to exercise this right to the fullest measure, nevertheless, were anyone to question the right of the assembly to do so, we would be prepared to seek the verdict of the people outside on this question, and all that need be done in this connection is to create necessary conditions which would enable people to express their will freely. Then your lordships may kindly see 257. If your lordship see in the middle, this precisely is the important section 370 of the Indian Constitution. The sovereignty and unfettered powers of the Constituent Assembly have been recognized by the Indian Parliament. The present constitutional relationship between Kashmir and India has time and again been made clear by the Indian government and its prominent leaders. The speeches made by late Sardar Patel, Gopalaswamy Iyengar, and Nehru himself in this behalf are still fresh in the memory of people. Then, my lord, please come to page 796. My lord, just as our Constituent Assembly had established committees, my lord, as your lordships recollect, to frame articles for different purposes. Similarly, my lord, the Jammu and Kashmir Constituent Assembly did the same thing. So they had a basic principles committee. What are the basic principles on which that constitution will be framed? And your lordships will find this is the report at page 796, and your lordships will notice the first. The basic principles of the state constitution will contain provisions relating to the form of the state, the executive, the legislature, the judiciary, the public service commission, the official language, and other ancillary matters. The recommendations of the committee in regard to these matters are contained herein below. And please see, my lord, the first line. The state of Jammu and Kashmir will comprise such territories which form the part of the state on 15th August 47, while retaining its autonomous character. The state will continue to remain acceded with the Union of India. The sovereignty of the state resides in the people thereof, and shall, except with regard to matters specifically entrusted to the Union, be exercised on their behalf by the various organs of the state. The governing features of the state constitution would be based on democracy, equality, and social and economic justice. So, my lord, they give the broad outline of who will be the head, elected minister, who will be the members of the Legislative Assembly, and please see page 798. The second paragraph. The judiciary of the state will be independent of the executive. And then, my lord, they write about the High Court, and the High Court will also be a court of record. Then, my lord, appeals will lie to the Supreme Court. All this, my lord, is a part of the framework. And finally, we come, my lord, to page 800. The state of Jammu and Kashmir the second para, my lord. The state of Jammu and Kashmir having acceded to the Union of India, it becomes necessary to define the relationship of the state with centre. This relationship was originally based on the instrument of accession, whereby the state of Jammu and Kashmir acceded to the Union of India in matters of defense, foreign affairs, and communication. When the Dominion of India became a republic, the relationship of the state with the Union was embodied in Article 370 of the Constitution. The state's accession to the Union entails certain responsibilities on the centre for protecting the interests of the state and also for its social and economic development. In order to enable the centre to discharge its responsibilities, which devolve upon it under the Constitution, those provisions of the Constitution of India which may be necessary for this purpose should be made applicable to the state in an appropriate manner. While preserving the internal autonomy of the state, all the obligations which flow from the fact of accession and also its elaborations contain should find an appropriate place in the Constitution. And then, my lord, please notice the recommendation Roman 1, that a directive be issued to the drafting committee to bring up appropriate proposals defining the sphere of union jurisdiction in the state, suggesting additions, modifications, and amendments necessary to the Constitution application of Jammu and Kashmir order to suit the requirements of the state. So, my lord, my submission is that the Constitution of India was made applicable with exceptions and modifications as a part of the Constituent Assembly's decision. It was not, my lord, an imposition by the president at all. And your lordships will see just at the bottom, the drafting committee should forthwith take up the drafting of the constituent for the state in the light of the recommendations contained in the report and such other reports as have been or adopted by this assembly from time to time. Now, my lord, the drafting committee did make a report. And let me take you straight, my lord, to that. Your lordships will find this at PDF page 936. At the bottom, your lordships notice, 11th of February, 1954. This, my lord, is the report of the drafting committee. In pursuance of the directives contained in the reports of the Basic Principles Committee and the Advisory Committee on Fundamental Rights and Citizenship, as adopted by the House, the drafting committee has considered the question how best to give effect to the recommendations embodied in these reports. The task which the committee has to discharge requires action in the following directions. Number 1, preparation of the drafting constitution of the state, defining the sphere of union jurisdiction in the state and for that purpose, suggesting the various provisions of the Constitution of India, along with modifications and exceptions, subject to which these provisions should apply to the state. These would include appropriate modifications and exceptions in Part 2, that is citizenship, and Part 3, fundamental rights, in their application to the state of Jammu and Kashmir, in the light of the recommendations contained in the report of the Advisory Committee on Citizenship and Fundamental Rights. But my lord, please see number 2, consequential amendments in the Jammu and Kashmir Constitution Act 1996. That is, my lord, the 1939 Constitution. My lord, the 1996 is the 1939 Constitution. Now, my lord, let us go forward. Please see the last para on that page. The annexure to this report, while reflecting the desire of the House for the ratification of the accession of the state with the Union of India, indicates in detail provisions of the Constitution of India, which generally correspond to defense, foreign affairs, and communication, and such other matters as are considered essential concomitants of the fact of accession. In accordance with the directions contained in the reports referred to above, the committee has endeavored to clearly demarcate the sphere of union jurisdiction, keeping intact all along the residual powers of the state. And, my lord, this has an annexure at the bottom. As your lordship see, my lord, that annexure A to the drafting report. This, my lord, is drafted by the Constituent Assembly. This annexure A. The provisions of the Constitution, which in, sorry, I'm sorry. Yes, I'm sorry, my lord. The provisions of the Constitution of India, which in addition to Article 1, and 370. My lord, this Article 1 and 370 is in the forefront of this annexure, should apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they should so apply will be as follows. So, my lord, preamble, then your lordships will see this proviso to Article 3. It says, cannot be introduced without the consent of the legislature of the state. My lords, all these are the exceptions and modifications wanted by the Constituent Assembly of Jammu and Kashmir to apply the Indian Constitution. And your lordships will also notice that this provided under Article 32(2)A, PDF page 940. There's a modification, my lord, of Article 32. Please see page 940 PDF at the bottom, 2A. Without prejudice to the powers conferred by clauses 1 and 2, the High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within whose territories those territories, directions or orders or writs, including writs in the nature, habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them for the enforcement of any of the rights conferred by this part. And then, my lord, Article 35, your lordships will find, protects the laws which were made specially at the time of the commencement of the order. And that's why, my lord, you have Article 35A at PDF 941 about permanent residence and they being specially protected. But, my lord, this annexure Goes on and on. Now, what your lordship see at 942, PDF 942, is part 11. In Articles 246, the words notwithstanding anything in clause 2 and 3, occurring in clause 1, and 2 and 3 and 4 shall be omitted. What they did, my lord, was they applied some parts, omitted some parts. That is, they omitted part 6 for states, they omitted part 7, they omitted part 8, they omitted part 9, they omitted part 10 of the Indian Constitution. And they applied this Constitution. And this, my lord, your lordships will notice, is verbatim the 54 order, my lord. And if your lordships now kindly come to 949 PDF, I'll now show you the resolution. I'll show, my lord, the Constituent Assembly forwarding it to the Government of India. Please come, my lord, to 949 bottom. Sir, the report is before the House, Mr. Dogra. It is being discussed for the last 2 days. When it is adopted by the House, the long-standing desires of this country, for which we have been trying for the last 6 years, will be fulfilled. Its adoption by the House will make the accession of this country to India permanent. We are acceding to that India which is the defender of peace and which is trying to check the possibilities of war. If in any part of the world war breaks out or any disruption is created, India extends a hand of friendship and peace and saves that part of the world from the disaster of war. All this, my lord, is said. Then please come to, my lord, again, they speak feelingly about India and India offering the hand of friendship. My lord, that is stamped all over the debates. All over the debates. Your lordships will find very adulatory, praiseworthy references, my lord. But now let us come, my lord, to the resolution, which your lordships will find is at the resolution is at page, my lord, 978. This report, my lord, was accepted. This annexure. Please come, my lord, to the end of the page, 978, Girdari Lal Dogra. Sir, I beg to move the following resolution. Resolution that having adopted the report of the drafting committee, and B, having thus given its concurrence to the application of the provisions of the Constitution of India in the annexure to the said report, this assembly authorizes the government of the state to forward a copy of the said annexure to the government of India for appropriate action. And at the bottom, my lord, is the chair at page 979. He resolves. It's to the same effect, my lord. Now, my lord, this report is sent to the government of India from the Constituent Assembly. Now, my lords, the 54 order, which has now been superseded, is, kindly see, this is CO 48. This is, my lord, 1954. But before 1954, my lord, they also passed a resolution under Article 373, which your lordships will find is reflected at CO 44. Please see page, my lord, a PDF page 12. This is documents volume D3, page 12.
Volume? D3.
Volume 3, my lord.
CO 44.
CO 44. My lord, all these were COs, they were all constitutional orders. That is why they have that nomenclature. And please see this, my lord. The Constituent Assembly was conscious of what it was doing. And it said, in exercise of the powers conferred by Clause 3 of 370 of the Constitution of India, the President, on the recommendation of the Constituent Assembly of the State of Jammu and Kashmir, is pleased to declare that as from 17th November 52, the said Article 370 shall be operative, with the modification that for the explanation in Clause 1, the following explanation is substituted. So, my lord, you have one order under 373 which says the only change we want in 370 is the change of the explanation from the Maharaja to Sadr Riyas. The second is they have asked for an application of the order, that is, my lord, the 54 order, also stating that Article 1 and 370 will continue to govern Jammu and Kashmir. Please see that. Now, my lord, this is the 54 order, which is at PDF page 13. And if your lordship see this order, in exercise of powers conferred by Clause 1 of
Where do we find that, Mr. Subramaniam?
So sorry, my lord.
Next page.
This is page, my lord, 13 PDF.
Yes. Yes.
Now, please see, my lord, it says, Article 2, the provisions of the Constitution, which, in addition to Article 1 and Article 370, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply, shall be as follows. All these, my lord, correspond to Annexure A, resolved by the drafting, your lordship have seen the Constituent Assembly, that Annexure A, which was forwarded to the government of India. This is that Annexure A. This is, my lord, in response to my lord, the Chief Justice's question again yesterday. Was there any action of affirmation by the government? This is the action of affirmation. And now your lordships will see their constitution recognizes the Constitution of India as applied to Jammu and Kashmir. I'm going to show that, my lord, in a moment. So, my lord, the two articles speak to each other. The two constitutions speak to each other. But that could happen only through 370. And now let us look at, my lord, the Jammu and Kashmir Constitution. As I told your lordships, there were so many parts of the Indian Constitution which were accepted in the 54 order. So, my lord, in their constitution, they first recognized the Indian Constitution. They said we are an integral part of India. They said we have powers to legislate, except where Parliament of India has power to legislate. And they, my lord, created their legislature. Their statehood, my lord, is defined by their constitution. And now let us look at, my lord, the J&K Constitution. Your lordships will find that in volume documents 2, please. This is, my lord, it starts at PDF page 1. And if your lordships will straight away come to the preamble of the J&K Constitution, Justice Nariman has also extracted it in his judgment. But, my lord, this is a collective decision of the people. And we, the people of the state of Jammu and Kashmir, having solemnly resolved, in pursuance of the accession of the state to India, which took place on the 26th day of October 47, to further define the existing relationship of the state with the Union of India as an integral part thereof, and to secure ourselves. And, my lord, many parts have been inspired naturally from our constitution. But, my lord, the word secular, Justice Cole observed that the word secular was not here. That's in some other part of this constitution, my lord. There is another article which deals with secularism. Now, having said that, my lord, please come to over the leaf, that is at PDF 17. They chose, my lord, 26th of January 57 to correspond to India's date of 26 January 50. This constitution may be called the Constitution of Jammu and Kashmir. And would your lordship kindly come to section 2, 1A, most critical, my lord. This constitution recognized, my lord, the Constitution of India. And how did it define the constitution is important, my lord. It defined into 1A, Constitution of India means the Constitution of India as applicable in relation to the state. So, my lord, we have an act of affirmance from government accepting the suggestions that the constitution should be applied. They say, please apply it subject to exceptions and modifications. And government agrees. And, my lord, they make Constitution of India means this constitution. And, my lords, please see, section 147 should be interpreted in the light of this. That the legislature can never touch Constitution of India as applied to them. And, my lords, the question will be, where does anybody get the power to abrogate this constitution? This is the central question in the case. Now, my lord, in addition, now please read Article 3 of this constitution in this manner. And, my lord, it is necessary that relationship of the state with the Union of India. The state of Jammu and Kashmir is and shall be an integral part of the Union of India. It is an integral part, my lord, on the strength of the 54 order and applying the provisions of the Constitution. And then please see territory. Territory of the state shall comprise all the territories which on the 15th of day were under the sovereignty or suzerainty of the ruler of the state. You know, this is the distinction which I answered in the morning in response to Justice Gawai's question. Please see 5. The executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. What, my lord, was attributed the expression residuary power, but, my lord, this is the rest of the power, excluding the powers of the Union Parliament. The rest is with the state legislature. Now, after this, my lord, you have to only see 2 more provisions. One is, my lord, I request your lordships to kindly look at section 92. But before that, my lord, I mentioned, please come to page PDF 25. The head of the state, my lord, is under this Constitution. Page 25. The governor, my lord, is appointed under this Constitution. The office of the governor finds a place for Jammu and Kashmir in this Constitution. And your lordships will find section 35 is a council of ministers to aid and advise the governor. Even this form of government is enshrined in this Constitution. And now if your lordships come to section 92, which is at PDF page, my lord, 59. Your lordships will find that this section 52 is 92, my lord, I'm sorry, is in stark distinction to the provisions in our Constitution. So, my lord, the purpose of section 5 was that 370 must continue, the list allocation must continue, 246, 2 and 3 must not apply. But now let's look at 92. If at any time the governor is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this Constitution, the governor may assume to himself any or all functions of the government of the state, make incidental and consequential provisions, and so on. But your lordships notice he is not in a position to exercise the powers of the legislature. And he has to do this, my lord, get popular government within 6 months. Because if you see 92.3, it ceases to operate on the expiration of 6 months from the date on which it was first issued. So, my lord, popular representative government is a part of the architecture of section 92 of the Jammu and Kashmir Constitution. My lords, as I mentioned, the High Court is constituted under this Constitution, PDF page 61. Page 61, my lord. Your lordships will see 93, 94, and 95. They refer to, my lord, consultation with Honorable the Chief Justice of India. And then Please see, my lord, the powers of the High Court at PDF 65. And now your lordships will find that that 54 order was treated as a part of law applicable to them. Please see this at 65, Article 103. When your lordships read the 54 order, I showed 32.2a. 32.2a, my lord, is only in the 54 order. And here your lordships will notice the High Court will have power to issue directions writs other than those mentioned in Clause 2A of Article 32 of the Constitution of India. My lord, therefore, the linkage between the 54 order and the Constitution of India as applicable has been cemented by the Jammu and Kashmir Constitution as well. And which is why the last provision, my lord, which I have to show you, is the amendment to the Constitution, 147. It has already been read. But, my lord, it is significant that the architecture of the second proviso at PDF page 85 makes 3 non-derogable, 5 non-derogable, and application of Indian Constitution provisions non-derogable. Please see that. Provided further that no bill or amendment seeking to make any change in this section or the provisions of sections 3 and 5. 5 also, my lord, is about their autonomy of lawmaking. 3 is, of course, integration with India, or the provisions of the Constitution of India as applicable in relation to the state. So, my lord, the provisions of the Constitution of India were not applied only through a 370 order. They were embraced into the Jammu and Kashmir Constitution. So, my lords, I conclude this portion by submitting. When we read Article 370, we should not be waylaid by that marginal expression temporary in the marginal note. But the entire article has worked out. Everything has worked out. It would be incorrect, my lord, to say 373 is OTOs. No. In terms of 370, they said we want to continue 370 and 1. We want only these exceptions to the Constitution, which means, my lord, they have expressly affirmed by a resolution that they don't want it to be abrogated. It is an express act of resolution. And that express act of resolution is accepted, my lord, by the government. And the order is passed. So, my lords, I submit that the vexed question, as if the Constituent Assembly was silent about the fate of 370, it is not correct. On the contrary, they wanted its continuance. They wanted it to be they wanted this to be the language of communication, my lord, between the two constitutions. So, my lord, if the Constituent Assembly of Jammu and Kashmir, which is the body of the people, if they have taken these proactive steps, we have accepted these steps, the question which arises, my lord, is, can we now abrogate this arrangement by that to unilaterally? Unilaterally. Can we, my lord, can we ever abrogate this arrangement? My Lord, there is nothing called hierarchies in constituent assemblies. In the definition, my Lord, your lordships will find theorists have written any number of books on constituent assemblies. The nature of the constituent power, my Lord, which is exercised by an assembly, is as pristine and pure as any assembly. This is, my Lord, this is the equality which we have practiced, my Lord. This is the level of statesmanship which India practiced and waited. Nothing was done in a hurry. And, my Lord, nothing was imposed. Whatever the Constituent Assembly wanted, we accorded. We accorded it. My Lord, this is the most important aspect. If this factual foundation, and this is beyond doubt, if this is so, my Lord, the question is, can the legislature of a state under the Jammu and Kashmir Constitution be rendered redundant? Can it be rendered, my Lord, redundant? And then the question, my Lord, is, what is the effect of those two COs, 272, 273? We'll go straight to them. You have only got to apply, my Lord, the degree test, effect test. What does it do? 272, 273. Let us look at both these orders. And let us see, my Lord, whether the power has been exercised in alignment with the purpose of the article. My Lord, the theory of ultra vires in constitutional law can be either in violation of Part 3 or unsupported by lawmaking power, but there is a third species of ultra vires if it is not aligned to the purpose for which it has been entrusted. Then in that case, my Lord, it is an action which is ultra vires. These two constitutional orders, if your lordships will kindly see with me, are in Documents Volume 3. And your lordship will find that PDF 101 is the first. Now, my Lord, the power which is now exercised, as your lordships can see, is the power under 370. The issue before us, my Lord, is, can the architecture of Article 370 obviate the requirement of the views of the other? I'm putting other, I'll develop what is meant by other. The views of the other. This is either the state legislature or the state government. But, my Lord, this is an article which contemplates that there is a state and a state legislature and a state government within the scheme of the Jammu and Kashmir Constitution. And it has been used under clause 1. In my submission, the purpose of power under clause 1, my Lord, is based upon a principle of mutuality. Because, my Lord, the article begins with the president, it doesn't mean that it is some untrammeled power. No. But there is an interesting thing in Article 371, notwithstanding anything contained in the Constitution. That notwithstanding, my lord, was necessary because there could be exceptions and modifications to provisions of the Constitution, especially for Jammu and Kashmir. And notwithstanding anything contained in this Constitution also tells us the supreme nature of this provision under 370. So, my lord, if we look at the components of basic structure, we have to look at the components of the basic structure as is reflected from the J&K Constitution, which applies the Constitution of India as applicable. Can that be abrogated? By reference to, my lord, the power under 371. 371, my lord, was a means of communication, was to respect each other. But that order does not, my lord, contain a power, if I may say so with great respect, to abrogate a legal compact. There is a legal compact, my lord. And this legal compact is of two kinds. One, of course, my lord, is the traditional social contract theory. But this compact is founded on federalism. That's why, my lord, leading authors on federalism, they often say that this is a different kind of social contract, federalism. So 370 established the contours of this relationship in the federal sense. My lord, this federal principle must be read as inbuilt in the application of Article 370. And that, my lord, cannot be abrogated. Now, please read the order with me. In exercise of powers conferred by Clause 1 of Article 370, the President, and let us not concentrate on the next few words, with the concurrence of the government of state of Jammu and Kashmir. What is that government, my lord, contemplated by Article 370 is the question. It was a government which was elected and accountable to the Legislative Assembly under the J&K Constitution. So, my lords, if it is so interpreted, this concurrence, which one must assume is the concurrence of the governor, is not the constitutionally mandated agreement in 370.